Good morning. Did you file anything for a bond?
Yeah, I've filed a motion for a speedy.
So he's gonna enter some pleas in the motion, and then what about the new case?
New case is pleaded not true.
Right here the judge feels the confusion before anyone admits it. This is one of those moments where the courtroom becomes a traffic jam, motions going one way, new cases another, and nobody is sure who's supposed to talk next. Classic setup for a procedural mess.
If there's administrative things, we can go through that.
Seems like execution.
I think the victim did a long prosecution. Or is it
I'm not saying no. I'm not ready to say anybody else.
Computers.
This is not my case. I'm just standing in for
Ms. Muffin.
yeah, that's for this. I can't speak to what she intends to do with the case.
I'm sorry, my screen is still loading. Is everybody's spinning? No.
I don't see a motion for a bond. We'd ask for 3 days. I'm not prepared to report on that for that advance notice.
Should have requested one in the letter, if not the motion itself, on the notice letter.
Request for probation bond and speedy hearing
Revocation hearing, yes, sir.
was filed August 18th. Let me just go through this motion first.
It's the same one always filed.
Mr. You're Nathan Lamel? Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So I'm just going to go through it.
All right, Mr. Lamel, in cause number 24, DCCR 0826, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of burglary of a habitation, April 26th of 2025. And is that true or not true?
Not true.
You weren't arrested?
Well, he was arrested.
That's what the allegation is. And I'm not, anyway, y'all, I don't know why they've changed them to just arrested, because being arrested isn't really a violation. Instead of committing the offense, all of a sudden all these motions are different. Y'all might want to take a look at that. They're not alleging.
This is a rare legal nerd moment. The judge is basically telling the prosecution your paperwork is sloppy, and trust me when a judge calls out bad drafting in open court, that's like a teacher catching you copying the wrong answers off someone else's test.
That they committed the offense.
I apologize, Your Honor. He was arrested, so that would be true, but I don't think it's a violation.
All right, so count 1, you're pleading true to?
Yes.
Okay.
You were arrested.
Count 2 alleges that you failed to avoid injurious or vicious habits as directed. I don't know what count 2 is either. No, just don't worry about it, because it doesn't say what it was, and so I don't think that is an accurate, I don't think I can go forward on count 2. Count 3 alleges that you failed to report to the probation office March 5th and April 9th of 2025, and is that true or not true? Count 3 is true. Count 4.
Just to be clear, I think what he said was it's true that he called in. So I don't know that he was.
Did you report or did you not report on March 5th or April 9th?
I'm not sure.
I think what he said was you didn't report, but you called in.
I don't need to know that. I need to know if you reported as directed on March 5th and April 9th of 2025.
We'll play not true. I think he's not sure.
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true? That's marijuana, THC. Did you test positive on May 1st? Speak up.
Not sure.
Okay.
Not true.
Count 5 alleges that you were at a location other than your residence at 3:01 a.m. on April 26th of
Bold move. Denying a positive drug test with full confidence is either the truth or a gamble the size of Texas, and in probation hearings confidence only helps if the evidence backs you up, otherwise it can backfire fast.
2025, and is that true or not true? Count 6 alleges that you tested positive on May 1st of 2025 for alcohol, and is that true or not true?
Not true.
Did you enter your pleas of true to counts 1 and 5 freely and voluntarily? And because those 2 counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence.
I think you pled not true, not to 5.
1 and 5?
That's my understanding. That's what I wrote down.
No, 5 is 3:01 a.m. I thought he said.
Not true.
Not true.
I wrote down not true.
Oh, I'm sorry.
He's
So,
only played true to number 1.
Right.
okay, so you're saying that is not true that you were at a location other than your residence at 3 o'clock in the morning on April 26th?
When you were arrested, that was your residence or wasn't your residence?
Oh, that was my reason.
He's saying it was his residence that he was
That's what I was
arrested at,
saying.
where he was staying. So it's not true.
Okay, count 1 then. All right, so I'm going to reset your case for a sentencing hearing. Obviously, the state can bring any evidence with regard to the allegations that you pled not true to. Also, y'all might want to make a note, go through if there's going to be any amended motions. Looks like I've seen several like this that need to be addressed.
Yes, ma'am.
It doesn't appear that the offense is alleged, Your Honor,
It's not at this point, correct.
but there's a non-prosecution on file for that.
That's-
so that
I don't-
may be
that's-
part of it.
All right, so we'll get an updated pre-sentence report in this case. And so Mr. Kimler filed a request asking that I set a bond in this case. Give me just a second before I get into that to go. I'm going to take a look, for the record, I'm going to take a look at the probable cause affidavit in cause number 25 DCCR 0744, which is that new case. So give me just a minute. Yes, ma'am, it's unagreed. I printed it. It's easier for me to read in person. Mr. Kimler, do you have any evidence with regard to that bond?
His ability to post the bond, Your Honor, is that what you mean?
Yeah, any evidence with regard to your request for a bond?
This is the bond interview moment where everything gets real. Judges don't just want to know if you have a job, they want to know if you're stable, reliable, and predictable. If you can't speak clearly, your chances of bond drop even faster.
Well, just that he's on, I believe he's on deferred, and what's your financial situation right now? Not too good, you employed, or did you lose your job because of your arrest?
I had a job, but I left New York for the rest.
Where were you working?
I had just started.
I can't, if I, don't make me tell you to speak up again.
I would just say he doesn't appear to be an absconder, Your Honor, and he's just a few days. It seemed to be.
Well, my issue, I mean, regardless, I guess, at this point, until we have more information about whether or not the complaining witness is going to go forward, is that it appears as though
Domestic dispute, Your Honor.
well, he had already been warned by the officer, I believe that same day, left with his mother, and then the allegation is he came back and then was aggressive with officers. And that the allegation is that there was a window that was broken and coming through a window, so that doesn't...
She knows she's not prosecution.
She is.
I think the alleged victim's present, Your Honor, if you want to.
I renew the state's position that we weren't prepared to go forward. In fact, on the bond today, in fact, there's no a copy of that letter that Mr. Kimley references. You may have a copy there, but I don't have a copy in the file. We asked for at least a couple of days to adequately prepare.
Did you just send that to us, or did you e-file it?
It was e-filed, I don't know if she
and-
tagged, I mean, I don't do not.
You gotta make sure they have notice of that. So at this point, what I'm going to do, hold on just a second.
She is present, though.
Yeah, we're not prepared to go forward.
Yeah, but they haven't talked to her or prepared for anything.
I don't understand why they didn't get a copy of the list if it's been filed.
Well, it was
It wasn't a motion.
a
No,
letter.
There's a motion filed.
We have neither a motion or a letter in the file.
Well, that's their problem, Your Honor. I mean, that's not mine. He's in jail. I mean,
Well, if it was e-filed and sent to the correct people, then I don't know that it's necessarily their problem or an electronic problem or a problem that your office didn't send it to the right person. So we're not,
but it was e-filed. My point is it's on file with the clerk. It's on file.
the state has to be aware of it. Just hang on a second. I see that he's in jail. It's a jail docket. I also have some concerns whether she's here or not with what was going on, because just because she says she doesn't want to prosecute doesn't mean that I think she's safe with him doing what this allegation is after he was trespass warned from going over there.
She's back further.
Yeah, I guess when you do need to make sure, I guess I have it from the 18th, a request for a reasonable
And here raise the tension spike even when a victim says I don't want to prosecute. Courts don't automatically stand down, especially in domestic or violent cases. Judges have seen too many situations where victims backtrack out of pressure, fear, or hope things will get better.
on and speedy probation hearing comes now, blah, 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 asking for it. An order was attached as well. So somewhere it got either lost or something wasn't done correctly, one way or the other. Doesn't matter at this point. We're here. My bigger issue is probably the same issue that the state's going to have. I want them to have time to talk to her. If she's going to file something and it changes the status of this, then we'll deal with that at that time.
She has filed a non-prosecution.
You have that in the file? Okay.
And one final thing I'll say on this is, it's one thing to e-file something, but it's a whole nother thing to make sure that you hit the tab or,
I've gotten there too. I've already said, I understand, and that's what I'm saying. If the right service wasn't sent, then it's an issue on your side that they didn't get it. Make sure it's done correctly,
To Ashley. I mean, you can see on the e-file notification
that it was sent to her.
to Ashley.
Okay, so it was sent. Is Ms. Malfino upstairs?
Yes, ma'am.
All right, let's get her down here real quick, please.
All right, this goes to.
This moment is courtroom comedy gold. Everyone is arguing about whether the file was sent, received, tagged, untagged, or magically teleported elsewhere. It's a reminder that half of courtroom chaos doesn't come from crime, it comes from paperwork.